banking on Africa's future. The initiative is to convert connections to community power. My first step will be converting this connection to a community who share the idea of problem solving as a community. The community is the Africa we want. We have identified a problem that is costing us to see the Africa I want. Now the problem is the mafia. Now the question is, who is the mafia? Who are the mafias? What makes them the mafia? And who appoints the mafia? There is a saying which says that I am because you are. You are because I am. You and me together in this, we can build the Africa that we want. There are many mafias. If you look around to see, if you stand up on your legs and not on your knees begging, you can see there are a lot of mafias. There is a gold mafia, drug mafia, fuel mafia, queen bee mafia, tender mafia, diamond mafia, Kotko mafia, Zinara mafia, ZPC mafia, land baron mafia, COVID gate mafia, and now this, the core of the dog series, the orange juice mafia. They say that it's wiser to look closer to home. We have been lamenting about these Western nations putting sanctions on us, thinking that it's exactly what's destroying the Africa that we want. But now if we look closer to home, we will find out there is this so-called the game of the mafias. It's an elite game. They're connected, they are in the top, they're all the mafias. So the mafias, are they responsible for costing us the Africa that we want? I don't want us to turn a blind eye into this. Are all these mafias saints or they are repentant sinners? I am sure facts will prove that. So before solving a problem, a shared understanding must precede any solution. So a shared understanding is that we have identified a problem, which are the mafias. So it's time to stand up with our legs, not on our knees begging, and build the Africa that we want, the Africa that we want to see, the Africa that we want to live in, the Africa that we want also our future generations to live into, the Africa that we want. The Africa that we want is one in which humanity is indivisible. 1 second to all, it depends on how you choose to live it. Do you choose to live fighting and building the Africa that you want? I choose to join this community. I choose to fight for the Africa that I want. I choose to make it possible. And join us on our next episode, where we'll dig deeper into this Coca-Cola issue, where these so-called mafias are well connected. They played a part, they played a hand. And this same Coca-Cola, a well-known brand, a well-known name, bigger than we all thought, is having a name that is being tainted black because of this so-called mafia. So are they involved in this? Are they clean or they are guilty? That we have to know. Facts will prove that. So join us on our next episode as we continue to provoke, to ignite, and to inspire the Africa that we want. Fire Dange. Greetings, welcome back again to the show. Remember, the initiative is to ignite, to provoke, and to inspire towards building and shaping the Africa I want. Today we are going to read an affidavit by Mtumwa Dzivamawere, the complaint in this matter. So, can we go through it? Are you ready? So I will start. This is what the affidavit is. We just read it as it is. I,
the undersigned Mutuma Dzivamawere, do hereby declare under oath the following. I am the complainant in this matter, an adult male of Zimbabwean heritage, and I reside at 325 Rivonia Boulevard, Rivonia, Gauteng, and the address of the association I belong to being Africa Heritage Society is also 325 Rivonia Boulevard, Rivonia 2128. The contents herein contain fall within my personal knowledge unless the contrary appears herefrom. In addition, the contents include documents and information obtained in the context of the banking on Africa's future, justice under rule of law, initiative of the Africa Heritage Society, an NPO registered in terms of the laws of South Africa, in which the following are duly paid up members. Number 1. I am the sole shareholder of Africa Resource Limited, a company that is duly incorporated in terms of the laws of the British Virgin Islands. Number 2. I am a director of Africa Resource Limited, and I'm authorized by the company to make this affidavit and to dispose to the contents. Number 3. I was the driving force behind the Scraps Private Limited localization and recapitalization program that was concluded in the name of Fidelity Life Assets Management, whose role in the program is set out in the evidence adduced by the then chairman of FLAM, Mr. Tendai Mundawara, to a commission of inquiry appointed by Mr. Gwaradzimba in terms of the Reconstruction Act, and his immediate successor, Mr. Solomon Tembo, in terms of his son affidavit deposed on 6 August 2004 before the CID unit of the Republic Police of Zimbabwe. I am requesting that an inquiry be conducted to determine the dispute regarding the relationship between the equipment whose acquisition and delivered to Scraps Zimbabwe Limited facilities and FLAM and SMM under reconstruction based on allegations made by Mr. Daniel Mokoena, the then Scraps Zimbabwe Limited and Coca-Cola South Africa Legal Counsel, to the effect that an amount of $2.7 exchanged hands between CCSA and the administrator, an organ of the government of Zimbabwe, as a consequence of fraudulent representations that were accepted by the CCSA, to the effect that Peter had spent the same amount in relationship to equipment that was purchased and delivered to SZL, with the direct involvement of Africa Resource Limited as the negotiating and de facto purchaser. Based on the above, the following persons will be of interest in this matter. Number 1, the CEO of CCSA, Coca-Cola South Africa. Number 2, directors of Coca-Cola South Africa as follows: A. Mr. Mpumelelo Masbuko. B. Mrs. Nokulunga Mtikiti. C. Mr. Eduardo Riad. Number 3, Mr. Dan Mokoena. Number 4, Mr. Attendorf. Number 5, Mr. Theodore W. Van den Havre, in his capacity as joint liquidator of Peter Trading Private Limited. Number 6, D&T Trust Private Limited. Number 7, Master of the High Court, Mr. Ntuwesen Setiahame, Johannesburg Office. Number 8, Mr. Mapaha of the Master of the High Court, Johannesburg Office. Number 9, Mrs. Pamela Duve, former Master of the High Court, Johannesburg Office. Number 10, Mr. Charles Musipa, CEO of Scraps Zimbabwe Limited. Number 11, liquidators of SAS, being A. Mrs. Karen Keefe. B. Mr. Norman Klein. C. Vincent Matsepe. Number 12, Mr. Afaras Mtlausi Gwaradzimba in his capacity as the administrator of SMM. Number 13, Miss Cass Simpson, DLA. Number 14, Mr. Pete Collin, ENS Africa Suntin. Number 15, Hannes Swart, Coca-Cola Africa. Number 16, J.M. Fitz Havinson of Cliff Decker Attorneys. Number 17, Coca-Cola Africa Private Limited, against whom this complaint is lodged, herein after referred to as the registered person, is a private company incorporated in terms of the laws of South Africa with the registration number 1986/0036669/07 with a place of business being number 18, 116 Oxford Drive, Houghton East at Johannesburg, 2198. Number 19, the General Counsel of CCA is Mr. Mpumelelo Masibuko, whose address is 116 Oxford Drive, Houghton East at Johannesburg. Number 16, the complaint is being brought in terms of Section 2 of the Constitution as read with Section 7.1, Section 7.2, Section 8.1, Section 25 of the Constitution that reads as follows. Wow!
We will continue again on the next episode as we continue to unravel the secrets and mysteries in this issue. On the next episode, we'll be talking about the supremacy of the Constitution, rights of the Constitution, application of the Bill of Rights. So we have to end here. Thank you for watching. Don't forget to subscribe, watch, and subscribe. And remember to provoke, to ignite, and to inspire towards the building of the Africa I want. Thank you. Vaya Dange.
Greetings. Welcome back to the show. Remember the initiatives to provoke, to ignite, and to inspire towards the building of the Africa I want. Today we'll be reading about the Constitution, the rights of the Constitution, the application of the Bill of Rights. So as we start on the supremacy of the Constitution, Section 2. And it says, the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and obligations imposed by it must be fulfilled. B. Bill of Rights, Section 25. Right to property. Point 1. No one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. 2. Property may be expropriated only in terms of law of general application. Point A. For a public purpose or in the public interest. And B. Subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to those affected or decided or approved by a court. C. Rights of the Constitution, Section 7. Section 7.1. This Bill of Rights is a cornerstone of democracy in South Africa. It enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. Section 7.2. The state must respect, protect, promote, and fulfill the rights in the Bill of Rights. D. Application of the Bill of Rights, Section 8 of the Constitution. Section 8.1. The Bill of Rights appeals to all law and binds the legislature, the executive, the judiciary, and all organs of state. Section 8.2. A provision of the Bill of Rights binds a natural or a juristic person if and to the extent that it is applicable, taking into account the nature of the right and nature of any duty imposed by the right. As a member of BOAF Juro, I'm extremely dissatisfied with the conduct of the following parties in relation to the conspiracy that seems self-evident from the facts and circumstances fully set out below. Point A. On 7 March 2003, I wrote a letter to Mr. Theodore W. van den Heuvel, attached here to marked EN1, setting out the facts supporting my allegation that this conduct in relation to the affairs of the insolvent estates of Peter Trading Limited in liquidation was inconsistent with the conduct contemplated in terms of Section 2 of the Constitution. Mr. van den Heuvel, despite the obligations imposed in terms of the Section 7.2 of the Constitution of South Africa that binds a natural person like him and a juristic person like D&T Trust to ensure that in terms of Section 25 of the Constitution, no one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property, refused, failed, and neglected to acknowledge and respond to the serious allegations made therein that Mr. Mutuma Mawere, a citizen of South Africa since 2002, and an Africa Resource Limited, a company that he is the sole beneficial shareholder, were arbitrarily and capriciously deprived of the property that Mr. Mawere personally negotiated and caused Peter to act as Africa Resource Limited's agent in relation to the fulfillment of the suspensive conditions pertaining to the recapitalization of the Schweppes Zimbabwe Limited bottling plant. B. It is common cause that the applicant creditor in the liquidation of Peter was Telnet Zimbabwe Limited, a company whose control and management was divested and deprived based on rights acquired by the government of Zimbabwe based on a decree that directly offends Section 2 of South African Constitution. C. Following the liquidation of Peter, Mr. van den Heuvel was nominated by Mr. Gwaradzimba and accepted to prosecute the right, capacity, interest, and title in relation to the assets of Peter, a South African juristic entity. D. By accepting to act as a joint provisional liquidator of Peter in liquidation, Mr. van den Heuvel knew and ought to have known that his conduct was immiscible to the rule of law as the alter ego of SMM under reconstruction was then Minister of Justice of Zimbabwe, Honorable Chinamasa, who issued an extrajudicial order that was used by Gwaradzimba to institute legal proceedings in the name of SMM as an organ of the government of Zimbabwe. E. The assertion, recognition and enforcement of rights acquired by force of a foreign decree in South Africa means that Mr. van den Heuvel, CCA, and the Master of the High Court, including the judges who presided over the liquidation disputes, were complicit in assisting the government of Zimbabwe to expropriate my fellow members, including Mutuma Mawere and Africa Resource Limited, of their right, title and interest in the equipment purchased and delivered to Scrap Zimbabwe Limited without the agents of SMM under reconstruction. The company hijacked by Chinamasa using public power. F. Based on the facts set out in my letter, whose link can be found here. You can find the link on the screenshot down there. It says, point 1. Set out in the letter above, reference letter to Ms. Van den Havre. It was pointed out on paragraph 8, A, section 2, that the late Mr. Kaplan wrote to CCA's employee, Mr. Hennes Swart, as follows. This letter serves to advise that I'm a joint liquidator of Peter. I attach here with copies of 3 contracts in respect of certain equipment purchased by the above mentioned company, Peter, in 2003. The parties to the contracts were disclosed to CCA and Mr. Van den Havre. This was disclosed after CCA had already intentionally and knowingly participated in extortion and fraudulent scheme perpetrated by Chinamasa, who was in terms of the repugnant reconstruction of state indebtedness companies, involving paying a bribe of 2.7 million US dollar as a quid pro quo for the release of Peter's equipment that was unlawfully hijacked by Chinamasa and his appointee, Kwarazimba, to the benefit of Scraps, CCA, and to the direct prejudice of Peter. According to the record of a meeting that ensued following the late Kaplan's efforts to take stock of the Peter equipment and deal with the property as prescribed by the Constitution of South Africa, the Companies Act and Insolvency Act, Mr. Kaplan did not attend the meeting of 31 July 2006, resulting in Mr. Van den Havre's appointee, Ms. Adendorf, attending the meeting with CCA and Swap Zimbabwe's Limited in-house legal counsel, Mr. Daniel Mukwena. Then F.2. The only record of the meeting that we have been able to access is a fax dated 12 October 2006 that was authored and sent by Ms. Adendorf via fax. Point 3. Serious allegations are contained in this fax that stand to be investigated further if this request for an inquiry is granted. Some of the questions that arise from this record that fall to be investigated include: Point A. CCA paid 2.7 million US dollar to Chinamasa in order to get the Peter purchased equipment as reflected in the contracts that were provided to CCA by the late Kaplan on 3 March 2006. It is clear that the reference to Peter in the fax by Ms. Adendorf as the supplier of the equipment pursuant to the purchase contracts that Mr. Mukwena disputed as evidence supporting Peter's right, title and interest to the equipment. It must follow that CCA must be fixed with the knowledge of the whereabouts of the Peter equipment. B. To the extent that Mr. Dan Havre has had knowledge of the dispute regarding the ownership of the equipment supplied by ADS, Kraus, Mafia and AF Industries, or European-based original platform equipment manufacturers, the failure and refusal by both CCA and Mr. Van den Havre to follow the trail of the documents, funds and physical equipment from the manufacturers to Zimbabwe where the important equipment was situated at Swap Zimbabwe Limited suggests a conspiracy and conduct that is inconsistent with the Constitution. C. It cannot be disputed that property does not self-create to allow both Mr. Van den Havre and CCA, with the knowledge and complicity of the Master of the High Court, to be indifferent when confronted with evidence provided by CCA's legal counsel, Mr. Mokoena, that point 1. Flame or SMM paid Peter the funds to acquire Sweb Zimbabwe Limited equipment, and at the time of SMM being placed under reconstruction and consequential liquidation of Peter and appointment of the joint liquidators including Van den Havre, the Peter equipment was specially installed, suggesting that the delivery of the equipment preceded Gwarazimba's appointment as administrator. 2. Common sense, logic and reason would precede any right, title and interest being vested in Chinamasa. 3. It was represented by Mr. Mokoena that Gwarazimba's reason for impounding the Peter equipment is that Flame or SMM had a financial interest in the equipment that entitled him to hold on the equipment based on an untested allegation that a reconstruction order existed. As a matter of fact, in relation to the affairs of Sweb Zimbabwe Limited and the equipment, that the later Kaplan had asked CCA to disclose its whereabouts to no avail, and to Sweb Zimbabwe Limited was purportedly removed from reconstruction. 4. It was made a condition for Chinamasa to issue a decree of 26 January 2006 to remove Sweb Zimbabwe Limited from reconstruction. 5. No facts exist supporting the allegation that Sweb Zimbabwe Limited was ever placed under reconstruction, let alone that the Peter equipment could be subjected to a law of Zimbabwe, and as such legal and valid authority existed allowing both Coca-Cola Africa and Chinamasa to divest and deprive Africa Resources Limited to the right, title and interest in the equipment through the agents of Peter. 6. Peter did not outlay any funds of its own in relation to the assertion made by Mr. Mokoena in his meeting with Mr. Atendorf. 7. After paying a bribe of $2.7 million, the purported reconstruction order or consideration for the decree being issued by Chinamasa, the hold on Sweb Zimbabwe Limited equipment by Chinamasa's agent, Gwarazimba, was released, and Coca-Cola Africa through Sweb Zimbabwe Limited acquired title to the equipment without following the prescripts of Section 25 of the Constitution, notwithstanding the fact that Coca-Cola Africa is a South Africa juristic entity. Any dispute regarding the relationship between Sweb Zimbabwe Limited and Coca-Cola was resolved when Mr. Mokoena, in his capacity as Sweb Zimbabwe Limited's agent, advised Mr. Atendorf that Sweb Zimbabwe Limited was CCA's subsidiary. Point 8. Any dispute of the existence of a relationship between Peter Mawere Africa Resources Limited in relation to the Sweb Zimbabwe Limited recapitalization was disposed when paragraph 8, 9, 10, 11 and 12 are properly constructed, which implicate Peter in the equipment ownership dispute. On paragraph 8, Mr. Mokwena's brief to Ms. Atendorf's brief is clear and instructive that some of the recapitalization equipment has been installed, meaning that the only equipment that was in reference to was the Peter equipment. It is instructive that Gwarazimba, in his capacity as Chinamasa's agent, advised Coca-Cola Africa, Flame and SMM, both Zimbabwean registered companies, and as such subject to Zimbabwe's stringent exchange controls, had paid some of the money owing to Peter Trading. This information would have led any independent and impartial liquidator to ask the following pertinent questions. 1. What money was paid by Flame or SMM that was purportedly connected to the Squares Zimbabwe Limited recapitalization matter? 2. When was this money paid? 3. How was it paid? 4. Who paid the money? 5. Did Coca-Cola Africa verify this information before proceedings to pay 2.7 million US dollar in relation to the purported relationship between Flame, SMM under Chinamasa's control? 6. What informed Coca-Cola Africa to accept Chinamasa's version through Gwarazimba that SMM had acquired the right, title and interest in the Peter equipment? Did Van den Havre take any next steps to verify the veracity of this material allegation that Flame SMM paid from Zimbabwe to Peter the alleged funds in relationship to the Scrap Zimbabwe Limited equipment? A fax from one of the suppliers of the Peter equipment clearly shows that Mr. Mawere, on behalf of Africa Resource Limited, visited the company in Munich, in Germany, in relation to the equipment and handled the negotiations to finality, and it was represented that Peter was going to be involved as Africa Resource Limited's agent, implying that Van den Havre was compelled to establish the bona fides of all the value actors in the chain of the European suppliers to the delivery of the equipment that was admitted as early as 2006 by Coca-Cola Africa after paying the bribe of 2.7 million US dollar to Chinamasa for him to use public power to issue a cassette on Cavan's letterhead. The 2.7 million US dollar was apparently paid to another Chinamasa's agent, and such Mawere, Peter and Africa Resource Limited knowledge about this corrupt deal falls outside their personal knowledge, and only Coca-Cola Africa has the right, title and interest to the stolen funds on the back of the theft of equipment that neither belonged to government of Zimbabwe and SMM under reconstruction. The inquiry should also examine the legal status of SMM at the time 2.7 million US dollar exchanged hands. Why this creature, an organ of the government of Zimbabwe or a company as universally understood? Point 10. It is not in dispute that CCA, Van den Havre and the Master of the High Court have known that Mr. Mokoena represented to the lawfully appointed joint liquidators of Peter that it was Gwarazimba who advised Coca-Cola Africa it should pay Flame and SMM under Chinamasa's control in order to get the Scraps Zimbabwe Limited plant back, which from the facts known so far was Peter's equipment pursuant to the contracts furnished by the late Kaplans on 30 March 2006. Yet the duties imposed on all natural and juristic persons were knowingly and internationally ignored and neglected to date. 11. It was known to all that cash equivalent in lieu of the CCA payment to Chinamasa was 2.7 million US dollar. 12. It was represented that Coca-Cola Africa voluntarily chose to misdirect the 2.7 US million dollar in relation to the recapitalization of Swap Zimbabwe Limited project to Chinamasa, and though it was represented to Mokoena that it was the administrator who agreed to release Scrap Zimbabwe Limited Flame from reconstruction, when no authority existed for the administrator who was appointed to perform only administrative functions in relation to the affairs the companies he was appointed to administer. He lacked title and jurisdiction to place Selenov TAP Zambia Swap Zimbabwe Limited Flame under his control. The legality and validity of the representation that Gwarazimba agreed to release Swap Zimbabwe Limited and Flame from reconstruction. 13. It was also represented to Peter liquidators that the property belonging to Peter was given to Coca-Cola by Kwarazimba, who lacked title and jurisdiction to advise Coca-Cola Africa to direct the payment of bribe of 2.7 million to perpetuate equipment payment in relation to equipment needed by SMM under reconstruction when no facts existed or were provided in relation to the Peter equipment, supporting Chinamasa's fraudulent claim using Kwarazimba that the conduct of Kwarazimba and Coca-Cola Africa in relation to Peter's property could pass the constitutional muster to permit Coca-Cola Africa to take title and interest from Chinamasa and not from Peter. 14. It is not in dispute that Coca-Cola Africa, without any court order to rely upon, voluntarily adhered to Kwarazimba's unlawful prescription, and as a consequence, Mawere and Africa Resource Limited right, title and interest in relation to the Scrap Zimbabwe Limited equipment purchased and conveyed through Peter was stored through an organized fraudulent scheme involving CCA and Chinamasa. 15. It is significant that Mr. Mokoena asserted to the Peter liquidators, purportedly represented by Ms. Attendorf, that Scrap Zimbabwe Limited or Flame were removed from reconstruction after paying $2.7 million in exchange for the government gazette by issued using public power by a public office bearer, Chinamasa, to the prejudice of Mawere and Africa Resource Limited and Peter as agent. Point G. The facts regarding the equipment ordered and paid for by Peter, it seems that no dispute exists as to the sequence of events and the fact that Africa Resource Limited caused Peter to act as an agent in the procurement of this equipment. However, the double payment was intentionally and knowingly orchestrated by Coca-Cola Africa as part of an orchestrated scheme to cause the control of Africa Resource Limited in relationship to Flame, SMM, Scrap Zimbabwe Limited to be divested and deprived from it using public power, and in relation to Peter using Mr. Dan Havry, who has known the facts regarding his travesty of justice that he led Vanden Molen Private Limited and she controlled to be unjustly enriched to the tune of 1 million rand, whose equivalent amount today is 3 million rand for just no cause. Age. The unquestionable and egregious conduct by CCA, supported by Mr. Van den Havry, has been brought to the attention of the Master of the High Court in terms of my letter dated 9 March 2003, and link can be found here, whose hard copy is marked EN2. Point I. The Master has also refused, failed and neglected to respond or take action as prescribed in terms of the Constitution and the prescripts of the Companies and Insolvency Act, suggesting that the justice system is in truth and fact broken. We end here. Thank you for watching. We'll meet again on the next episode. Thank you. Fire Danke. Greetings, family. It's good to have you back. We are still going on with our topic. On the last episode, we opened up on the payment made by Mr. Mawere and his agent to Alstom in terms of purchasing the equipment, and also everything, the full value, the first 50% they paid and the last 50% they paid, and also the money that Coca-Cola paid as well in full, which is something that we need to go through again
Why did Coca-Cola has to pay, or is it? And then also we dig deep into that question as to whether Coca-Cola lawfully and validly acquired the Zimbabwe scrap equipment purchased from Van Dan, Moulin and Alstom. So that's exactly what we want to go through today. We just want to give you some of the emerging facts in this issue. And also remember, we're driven with the initiative that is to provoke, to ignite, and to inspire towards the building of the Africa that I want. So I just want to take you through. We got together. I want to take you through on this document that we are reading at the moment. And it says, in terms of the email of 16 November 2006, or after the facts of 12 October 2006, the following facts emerged. So after the email, after everything was concluded, so these are the facts. All right, we start with point A. Scrap Zimbabwe Limited requested Alstom to submit a quotation with the reference EX27439 for their supply of 11K indoor switchgear to Scrap Zimbabwe Limited. So that is Scrap Zimbabwe Limited. It required a quotation. They want to buy from Alstom. They required a quotation for the switchgear, 11K indoor switchgear. All right. And then on point B, these are the events. On point B, on 10th of March 2004, Alstom submitted the quotation. The quotation which was requested by Scrap Zimbabwe Limited. Alstom replied with the quotation. Okay. Then on point C, on 13 April 2004, Alstom received an order from Scrap Zimbabwe Limited for this equipment. The equipment that they requested a quotation for with the reference EX27439. Then they made an order. Scrap Zimbabwe Limited made an order. I want you to get me right. Made an order for that equipment. Then on point D, on the 8th of July 2004, Alstom received 50% of the order amount in order to commence the processing order. So this is another development. After they gave a quotation to Scrap Zimbabwe Limited, on 8th July, Scrap Zimbabwe Limited, they paid 50% of the full amount needed. They paid is more like a deposit, 50% deposit, so that they can process the order. They can commence the processing of the order of that indoor 11K indoor switchgear. They paid, Scrap Zimbabwe Limited paid 50%. Then point E, the pair was Mr. Mawere's subsidiary company within the African Resource Limited group of South African companies, Southern Asbestos Sales. So the person who paid for this is a company of Mr. Mawere. It's a subsidiary, one of his companies, which is Southern Asbestos Sales Private Limited, is the one which paid the 50%. Okay, so the 50% was paid. It's more of an upfront, like I can say. And then on point F, on 16 July, the balance of 164,717 rand and 50 cents was paid through the agents of SARS. Okay, you get it right. On 16 July, which means 164,717 and 50 cents is the balance left. So they paid another 164,717, 50%, and now on 16 July they paid the balance. On 8 July they paid 50%. On 16 July they paid the balance, which means they have paid everything. Okay, is the full amount. So which means Swap Zimbabwe Limited doesn't owe Alstom anything. They paid. So once everything is paid, which means they have to deliver. Okay. They need to deliver. You have paid for something. It has to be delivered. So now we are waiting for delivery, and this is what happened. We got to point number 6. Coca-Cola South Africa, with the knowledge and involvement of Mr. Mawere and of Africa Resources Limited and or its associate companies, paid 329,435 on 5 August for the full value order that had already been paid in full at the instigation of Mr. Mawere pursuant to the Swap Zimbabwe Limited upgrade recapitalization program. So here's a question. Remember, I gave you the development that Swap Zimbabwe Limited, they paid the full amount, but now we have got another issue. Coca-Cola South Africa then paid the other full amount of 329. Remember, they never requested anything. They never requested the quotation or made an order. Now they paid. So which means the money is being doubled. What's the reason of paying double? What's the reason of this? While this Swap Zimbabwe Limited is waiting for the delivery of that which they paid for, it has to be delivered. Now there comes another situation where Coca-Cola South Africa then, in the midst of all this, paid the full amount. For why? That we have to know. And then point 7, as a consequence of Coca-Cola South Africa's arbitrary and unilateral actions, Alstom was double paid. So that is what we are talking about. Alstom was double paid. Okay, so now who has the right to tag the equipment? Coca-Cola South Africa paid, though they never made an order of anything. This is what is being said. They never ordered anything. It was Swap Zimbabwe Limited which ordered and paid through its agents and its subsidiary companies. It paid the first 50% and finished the other. But now after this Swap Zimbabwe Limited has been done, is finished paying, Coca-Cola came and paid, and they double paid. So that's the question. Why did they have to do that? So the question that arises is whether the right, title and interest in the equipment was lawfully vested in Africa Resources Limited, or the payment by Coca-Cola South Africa on 5 August 2004 nullified the full payment by Africa Resources Limited, which was affected prior to the entry of Coca-Cola South Africa into the value chain. So this is what we are asking ourselves, okay? Who has the right for the equipment? So you're asking yourself, Swap Zimbabwe Limited paid the money, paid the full amount. But the question is, the money that was being paid by Coca-Cola South Africa, did it nullify the payment made by Swap Zimbabwe Limited? Did it nullify the full payment made by Africa Resources Limited? It gets into the value chain, right? It paid double money. Why did it do that? So then the money that they paid, does it mean that they now have the right to the equipment? Who has the right? The two entities, they paid. So now who has the right? That's what we have to know. So one confusing fact now, that's what we're asking ourselves, why did they have to, this Coca-Cola South Africa, why did they have to pay double? Actually, something they never ordered. Because I don't see any proof that they ordered something. It was Swap Zimbabwe Limited that ordered. Got the quotation, ordered everything, paid the 50% deposit, and later on finished. While they are done finished, then Coca-Cola South Africa come and pay. So the question now is, since now it's public knowledge that it has been double paid, okay, so here's something to take note of. Coca-Cola South Africa refused, failed and neglected to recover its electoral payment to Alstom and Chi Control. So why did it have, it's a lot of money, why did they have to refuse? They refused, they neglected it. Oh, this one is done, we don't know, maybe they say it's done, we don't have anything to do with this kind of money and everything. So that's what we are asking ourselves, why did they have to go and reclaim their money since they never ordered anything, but they refused to recover? It's a neglected man, they refused to. So that's the question, why did they have to refuse? What is hidden in between? What's their agenda? I'm sure there is something to look forward to. Why did they have to refuse? They know it's been double paid, but now they refuse to pay or to recover the money that they paid. Why? Why is that? So that is something that we need to look at, take note of that. Why did they know, but why did they refuse or neglected to recover its unilateral payment to Alstom? They know it's been double paid, but they refuse to recover it. Why? So that why part, why did they have to refuse? Unfortunately, we have to end here. We have to end here. It's been a pleasure. We'll meet again on the next episode as we go on to try to find validity and the legal process in this in Coca-Cola South Africa's overpayment. They overpaid. We want to see what's the legal side of the story. Is it valid? That we have to know on the next episode. And thank you for watching. Subscribe and like and share the message via Dange.